Hi, it's Brian Ponder, Brian the Credit Lawyer. Today we're going to talk about when can I sue? I get that question a lot. Do I have a case? Well, that's sort of a complicated question, but let me address it in a few ways. First of all, I get that question a lot recently from some credit repair specialists. Do I have a case? When can I sue? Will you take the case? Well, there's a lot that has to be shared before anyone can make a wise determination on whether or not there's a case or you should sue. Um, Specifically, recently I had some people contact me saying, hey, I disputed this and it came back verified. Even today, I got a inquiry about a credit repair person that disputed something with the Consumer Reporting Agency and with the debt collector. The Consumer Reporting Agency came back and said it was verified, and then a debt collector came back and said they were going to delete it. Well, they were both about a day apart. One was maybe, I think the Consumer Reporting Agency on the 3rd of the month came back with a verification letter, and on the 2nd of the month, the debt collector said they're going to delete it. And so the question was, well, can I sue them because they verified it? Well, no, you don't jump the gun. The debt collector said they're going to delete it. It takes time for that deletion to show up. Obviously, those things may have crossed in the mail or transmission, not mail, but transmission. So the deletion request probably came after the verification. So wait for the deletion to occur. Now, this would be different if you had a verification and the debt collector came back and said, oh, well, we're not deleting this debt. We believe it's a bona fide debt, a valid debt. Here's the verification. And for verification, they send something that's not really verification. It's not really an agreement to the debt, but some statements or something like that. Or the name of the creditor. It's nothing that proves that the debt is a legal debt and the amount they're trying to collect is the proper amount. Now, in that case, that's something that could be examined and looked at from a violation standpoint, depending on the circumstances. But even in that case, if an attorney has not written a demand for it to be deleted, I would feel very uncomfortable with a case where the attorney just grabs it and just jumps right into litigation without attempting to get it deleted. And online, there's a lot of nice cases and results with people winning thousands of dollars for violations, and that's true. But these cases have to be worked out properly. Courts do not like for you to jump to litigation. Why? Because the FDCPA provides that if the debt collector made a bona fide error, then that's a complete defense, assuming they have reasonable procedures in place to prevent those types of errors. So, to prevent that, you have to give that debt collector, I think, at least as an attorney, notice to correct their error. Now, you may think, well, I sent them a letter. Well, the consumer letter or dispute letter it's a little different than an attorney demand. So the courts may look at it like the attorney should have specifically and explicitly identified the issue so that they could correct it. And the types of disputes that I recommend from the consumer are so broad, the debt collector could try to rely on the fact that, oh, we didn't know specifically that was the issue. So again, by the time it gets to a lawyer, the lawyer needs to take a stab at it, which typically virtually always ends up in a deletion, and then you can let it go from there. Now, some people, even with the deletion, want to go back and say, well, at the time it happened, it was a violation. That's not wise. You could spend a lot of time and resources in litigation when a bona fide error defense could just totally destroy the case, and it could be a waste of time. If you have a debt collector that eventually complies once they get a demand from an attorney, I think you should be grateful of the result and just move on. Only those stubborn debt collectors that don't correct and delete and stop collecting on debts after attorney demands that they do so, those are better cases to pursue litigation with. But keep in mind, the client and their results is a top priority. Not litigation, not receiving damages, especially when it's corrected. But when it's not corrected, that's when I think it's time for litigation. Same goes for consumer reporting agencies. When something comes back verified, at that time I think it's a good time to turn over to a lawyer. The FCA is a little different. It does not have a bona fide error defense. So just putting together a report that's inaccurate and incomplete, if the consumer reporting agency did not follow reasonable procedures to do that, to make sure everything is completely accurate and complete, you have a case right away. So those kinds of cases are ripe sooner than debt collection cases, because the FCRA has stricter provisions that require consumer reporting agencies to follow the law early on, as soon as they put together this report. However, you still need to go through a dispute process. Sometimes a lawyer may get your dispute and determine that dispute was not on target enough to really form the basis of a case, and may end up helping you, the consumer, redispute that issue. But for the most part, you know, after it's disputed and verified and the review of the dispute is sufficient, it may be ripe for litigation then, or again, it may require another attempt at a dispute that has a different angle that the attorney may find appropriate. Please like, comment, and subscribe to my channel, and feel free to comment to ask any other questions that you would like answered. Thank you.